local government, where I was a chief officer for about 9 years before moving into the private sector. But I'm not a construction lawyer, but I'm not sure it's particularly important in terms of what we're going to cover in this session, because it is actually very largely about principles of approach rather than necessarily the nitty-gritty of the details. And I think, as you'd expect in a webinar, the intention here is to assume people know nothing, that you've all just got off that boat that's arrived in St. Vincent. But hopefully, in the course of this webinar, we'll gain some insights that if you get one insight, then I will be satisfied. Walker Morris is hopefully a reasonably well-known firm with a national international client base based in Leeds. We've recently moved to our new premises at Wellington Street, so not the best year, I suppose, to have a major office move. As I say, the firm is well known to Efficiency North, and for those that don't know, we are also on Lot 2A of the CCS framework. So if anyone has any follow-up stuff, the firm as a whole is fairly accessible to the public sector. Okay, without no more ado, what is PPN0220 and who does it apply to? It's the second policy procurement note issued by the Cabinet Office, Crown Commercial Services Agency. The first, which Carl's mentioned, was the subject of a webinar a couple of weeks ago, concerned Policy Note 01, which touched on the urgency provisions. Essentially, no new law, just advising authorities, public sector bodies, how they can use the urgency provisions in the PCR to help them navigate either fresh procurements or changes in existing contracts, and hopefully, if anyone's got time for it, avoid litigation. So I won't be intending to cover that in this session. The PPN was issued around the 24th of March and published on the 27th, I think. It runs, 20th of March. It runs to 8 pages. As Carl said, it's been supplemented by FAQs and guidance on model terms for goods and services contract on the published on the 24th. Landed on the website on the Monday, the 27th, and then on the 6th of April, there's a 30-page document which touches on construction contracts and covers FAQs and includes in it some model deeds of variation. The coronavirus scheme is separate and subject to its own guidance and sector commentaries. Certainly where the Local Government Association has given guidance on that on its application to council staff and council undertakings, and I'm not intending to cover that. CCS is the largest public procurement organisation in the UK, Efficiency North, and is available to support all public and third sector bodies. It's an executive agency of the Cabinet Office and operates as a separate trading entity, and its chief executive officer reports to the minister, and the agency is basically scrutinised by Parliament. And that's relevant in the sense that other government departments and agencies will be expected to give a very high degree of consideration to the views of and the policies issued by Crown Commercial Services and the Cabinet Office in this way. And it'll be policed by the relevant accounting officer and parliamentary and other scrutiny processes that government departments and agencies are subject to. But it's not a statutory or regulatory body exerting direct control over other elements of the broader public sector in which registered providers, local authorities and other bodies governed by public law sit. And for this reason, CCS Cabinet Office views expressed through the PPN are relevant guidance, but they don't determine how you should behave. In a recent webinar, a leading advisor to the sector commented that it had sought clarity from CCS whether the PPNs applied to registered providers, and commented, CCS have confirmed that RPs can decide themselves whether they want to be covered or not, and each organisation can make their own determination. Further, in the light of the above, RPs have a discretion whether they will or will not apply the best practice set out in the PPN, given the patchwork nature of their status as public sector organisations, their charitable aims and objectives and the indirect nature of their funding from HMT, this might be a position that many will reasonably take. Now, at face value, I'm concerned that that's somewhere between misleading and an oversimplification. And I think it's important in getting through the rest of this session to be clear on one or two issues. So the PPN is guidance and no more than that to RPs and LAs. It has no special quality, although as a major procurement entity and to some degree an arm of government, it will set the tone of how matters like this are likely to be dealt with in the broader market. Following, it still requires authorities to properly consider the risks, the contract terms, their instruments of governance and statutory powers. That is what you would expect. It's no substitute for any of that. It's guidance to contracting authorities. It's not aimed at the contracting sector. And the quote I've just given you, I think, confuses the status as a contracting authority with the relevance of the PPN to the organisation. Whether and when a housing provider is a contracting authority under the PCR, as you know, many will be listed by the social housing regulator or will meet the test of bodies governed by public sector, by public law, which is set out in the PCR, where there are 3 tests. And being a contracting authority is not, as was suggested, a matter of discretion. It's a function of applying the facts to the law. The PPN is advisory only for RPs and LAs who are contracting authority. It's not necessarily best practice, not least since it's not been tested in implementation. And for those of you that have had the opportunity to read it, it's riddled with references to taking legal advice, looking at the facts, and so on. Even to non-contracting authorities in the private sector, CCS guidance will carry a degree of weight, but organisations, as I say, must still address facts and circumstances, must understand what the needs of their counterparts are, consider their governance obligations before deciding whether to take action. The suggestion that many will reasonably take the decision that the PPN is of no relevance to them is not correct. However, as a public body operating within an accountable public law framework, you will be expected to demonstrate an element of, or a high level, should I say, of diligent consideration. But I'm not suggesting that a failure to slavishly apply the PPN will render you susceptible to judicial review. The PPN does encourage targeted measures of what I'll call generosity towards the contractor for the greater good, as described by Carl in his opening remarks, and particularly in circumstances when the contract terms may either not deal with it at all, or deal with it partially, or potentially deal with it harshly in the sense that the service provider contractor is opened up to penalties, damages, termination rights, and so on, and with it cash flow difficulties. So being asked to, as it were, step up to the plate and give consideration to this is certainly going to challenge organisations who will need to carefully consider their fiduciary responsibilities and their exposure. Now, I'm going to pause for questions there on the question of whether it applies to people. I'm going to come on in the next session to really look at how it applies and what the detail of that is. And so the first bit really is the relevance of the PPN and the status of organisations and how they should have regard to it. So, Carl, are there any questions on that? And if not, I will move on.
Just using chat. Nobody's asked a question using chat yet. I probably should have reinforced that actually. So if you do have any questions while David's talking in one of these sections, if you can use the chat function, and then I can basically open up the conversation really. So
okay. We can pick them up at the end if we get through this or in the next session. But if there are none at the moment, I mean, all of what I've said, hopefully, ought to be the position as people understand it, rather than any big nuggets. Okay, I'm going to move on.
Just David, in terms of the clarification, obviously the guidance notes in the FAQs imply that the PPN02 applies to all contracts let under the PCR regs. Now, obviously, all of our members generally have let contracts under the PCRX, hence why they use frameworks in order to satisfy that position in effect. So the guidance notes imply that it applies to everyone that lets under the PCRX in reality. But as you say, that clarification gives a bit of a carve out, as you say, as you mentioned, for RPs to sort of take it on board, and it is purely guidance at the end of the day.
Well, it is purely guidance. I think the problem that the sector has struggled with for many years is that for some time, incorrectly, it was thought that the PCR didn't apply. We then get to a position where grudgingly, because they've given the wrong advice, government indicated that it was prepared to accept it did apply to the sector and that the relevant tests were met. But increasingly with the nature of organisations, it is possible that some sit entirely in the private sector and do not meet the tests of bodies governed by public law. But as a general statement, I suspect that all, if not most, of the people on this call will either be listed organisations in the public sector or will be listed by the social landlord registrar, etc., or meet the three tests. Yes. But I think the suggestion that RPs can just decide whether they have regard to it is not right. What you do with it is a different thing.
Absolutely, and we'll move on to that next, I think, as you say.
Yeah, okay. So we have the guidance, second session. How might the PPN be applied in practice? And that really, for my purposes, means what does it say and what sort of issues does that throw up? I think a good starting point, as always, is going to be to say, what would you do as a good contracting counterparty do if a contractor turned around in these sort of circumstances, absent COVID-19? And then I think the supplementary question is, given the nature of the reasons giving rise to this problem, which are out with the control of the contractor, what do you think you can do? And this is the sort of public policy thing. What do you think you can do, which will be for the greater good, but ultimately is intended to avoid you having service failures, reprocurement costs, and doing your bit to kick the supply chain down the road, because that roughly is what the PPN is pointing us to, which is please do what you can to keep the economy and the supply chain intact as much as possible. So some questions that I was given were practical ones like how do you avoid doubling up on costs under the scheme and payment relief increases to RPs? What do you do if they fail and that sort of thing? So I will pick those up as I go. So I'm going to step through the guidance and make some emphasis. So it is information and guidance, and it is couched in the language of should. You should not go away thinking that somehow this is a directive which is mandatory and so on. The objectives are, as Carl's indicated, to ensure service continuity during and after the current outbreak, to ensure supplier survival through continuing to pay them, to ensure continuity coming out of the pandemic, and in particular, in order to keep key personnel in place and suppliers in place. Now, you're encouraged to work with suppliers to identify suppliers at risk. That was one of the questions, which is, should you have to take the initiative, or surely wouldn't you expect anyone at risk would be knocking at your door? I think, rather than spend too much time on that, I think it's a question you need to have with your suppliers, because it is likely that there will be disruption and failure, and therefore promoting the dialogue is really at no substantive cost. Again, what you do about it is up to you. But the emphasis of the guidance is that it's very much for the supplier to articulate what it needs and to demonstrate and evidence that, including evidencing mitigation, rather than you providing them with a blueprint. The guidance suggests that part of the overall objective is to try and pay as normal until the end of June. As Carl's hinted in the FAQs and so on, and the drafting, there is the suggestion, of course, that this may continue. The objective is to improve cash flow to suppliers, for example, through prepayment and interim payment. and clearly that gives rise to risk that I'll come on to a bit later on. Payment by results, in the sense that where you have a regular contract, the emphasis is to maintain cash flows at or about the level of the previous 3 months, or as agreed. You're encouraged to look at improving the speed of payment. So in addition to things like interim payments and potentially in limited circumstances advance payments, you're encouraged to improve the speed, turnaround speed, and address reconciliation against the facts later. So really stepping outside of what historically is the day-to-day comfort zone on these things. Yeah. At a practical level, there's a need to adjust milestones because they will be being missed. I should say, of course, the background assumption here is that the existing contract terms, as I said, I think in opening, don't properly cover things off. So the expectation is that you will look at the thing in the round and as necessary make adjustments. So adjusting milestones will be necessary. Implementing open book, making cost data available. The aim of that is to make sure that as you're feeding cash in on a weekly or monthly basis, that you're satisfied that the claim is justified, you're satisfied with where the money's going. And one of the things that the 6th of April guidance did, aimed at construction contracts, is encourage the emerging use of project bank accounts, the purpose of which is to create effectively a trust-related account, so that if the supplier does go belly up, the money isn't lost. It's also a very transparent way of your organisation making sure that payments go to suppliers and staff as appropriate. So if appropriate, you ought to grant relief from contract terms such as KPIs and so on to maintain business continuity. Insolvency risk is recognised, and of course that's put back to each organisation by saying, well, you need to consider it on a case-by-case basis. It's difficult to sort of understand quite what the insolvency risk is, because most organisations' last accounts will have predated, of course, and could not predict what was coming. So really this is a bit of a minefield. But you're not expected in terms of the guidance to undertake slavish analysis, and that's probably because the facts just aren't out there. Bonding, if you make advance payments in advance of delivery of whatever nature, bonding is unlikely to be given for such a short period of time. You may have in place an existing bond that might allow you to rely on it, but you'd have to look at the terms of the bond to make sure that it dealt with this change in contract. Parent company guarantees, if you've an effective parent company guarantee, of course the working assumption is that the whole group won't go down, but it does avoid, I suppose, the slim risk that if the subsidiary construction FM company went down, then the parent at least is acknowledging that it will stand behind it as best it can, because it may have real estate and other assets which are not readily available to be liquidated and used to support its subsidiary. Insurance, unlikely. Come on and say a bit about that in the future bit. Insurance unlikely to be available. Retentions and payment delay are typically a measure that organisations use to create, as it were, a bow wave of cash in their favour against the underperformance of a contractor. Both of those are discouraged by the guidance, albeit if the services have been substantially delivered and there is a relatively modest retention at the end, then you're encouraged not to give way on that. Another thing that organisations might do is, if you're giving advance payment, is you might want to look at making sure that there's no difficulty with obtaining title to anything brought to site, and there aren't any difficult retention of title clauses which would, say, give you difficulty. And then last but not least, something that you might do if you're exposing yourself financially, you might say, well, I'll try and take some other form of security. But of course, in this market, there'll be plenty of prior secure creditors and lenders, should I say, over the assets of the company, and you will not resolve the issue of proper security in the time available. So you're having to take a view here, I think, rather than necessarily have the usual instruments of security. Anyway, carrying on, you need to identify what's being paid for and that's being done and what's being paid for that's impacted by COVID-19. That's clear. There has to be a sort of clear split. And payment should not be made to suppliers where there is no volume commitment. And that comes up in one of the examples I'll touch on shortly. You could always, in those circumstances, of course, issue an order. But the example that the guidance gives relates to a framework contractor where you may be one of half a dozen and effectively there's nothing to pay you for. You're also cautioned against making payments to suppliers that are underperforming and are subject to an improvement plan. It doesn't say, of course, that you can't, it just suggests that you perhaps should not. And again, these are all individual decisions for organisations. There may be good practical reasons why you would nonetheless seek to continue to support an underperforming contractor rather than let it potentially go to the wall. Profit is prescribed here. There's no profit to be taken on undelivered items, but the pricing may well include some element of regular overhead charges. You're encouraged to consider whether there's opportunities to redeploy supplier staff through a variation where effectively you'd otherwise be paying for them, but the public sector would be paying for them, but you can use them in another way. The guidance is valid until the 30th of June. It doesn't address contracts that are in the course of being let, but you would expect anybody who was letting your contract now to have regard to it. And if suppliers seek to pursue relief, you're encouraged to try and agree with them bespoke time-limited variations on the basis, as I say, that by and large the existing protections under standard contracts don't cover the nature and extent of what is going on. So in addition to the PP, so that covers that's a canter through the PPM. The FAQs, do they add anything? The question about suppliers at risk, you're encouraged to apply it broadly. I think the expectation is the majority will be at risk, and you're expected to make judgments without detailed analysis, but you will need to document what you're doing so that in the court of public opinion, if in no other location, you can justify the actions that you thought were right to take at the time, but with the benefit of hindsight may look to be less beneficial. The assumption is payment should be as normal till the end of June, whether or not the services are being fully provided. As I say, there is a need to mitigate, but the expectation is the payment stream will be as normal. And if a supplier is being paid in full, the terms of the variation should provide that they won't make staff redundant and also will include provision to avoid doubling up, i.e., they put staff on furlough under the scheme. So payment still requires a basic level of due diligence, but you're being asked to take a relatively quick high-level view of the situation. Payment in advance has been mentioned. Payment in advance is not a gift of money. Performance is expected at some point, and I will come back to that. Question 13, I've touched on doubling up with the coronavirus scheme. Not to be allowed. 0220 is about continuity and retention. Doesn't allow them to claim under the scheme. And if you're in a situation where supplier staff are partly used on your contracts and partly used in the private sector, then you need a discussion about furloughing those staff that provide a public sector element. All these things should be picked up in the variation. And question 15 in the FAQs leaves open whether a supplier must provide the service or must pay back overpayments. And it says this should be agreed on a case-by-case basis. I have to say, when you were reading the guidance, you'd think, surely the expectation is they are going to deliver for the advance payment. So it is rather curious that future performance is seen as being agreed on a case-by-case basis. So I'm going to come now on to how do standard contract suites deal with COVID and give a couple of examples. As I say, I'm not a construction lawyer, so My construction colleagues have helped me out with this. So the JCT contract provides for two relevant events. One is the exercise of a statutory power, not as a result of a contractor default. The COVID regulations are indeed such a power, and thus will allow an extension of time under a JCT. Force majeure is drafted to be anything beyond the reasonable control of either party. These are in the standard form, because it's fair to say that there are many amendments often to these suites, but the standard form is anything beyond the reasonable control, which renders the contractor unable to perform its obligations. And the pandemic, again, is likely to be considered such an event. But as you may know, with force majeure, it doesn't apply if it merely makes it less profitable or more difficult to perform. The contractor has to demonstrate that it's unable to perform. Workforce availability and supply chain issues. There's a sort of margin here where any contractor has to take on the chin sickness in the workforce and difficulties in the supply chain. They are not automatically going to give rise to force majeure, but it's the nature and extent of what's going on at the moment that should mean they can readily demonstrate it, but again, they must demonstrate it. JCT deals with relevant matters. So we looked at relevant events. Relevant matters entitle contractors to loss and expense. However, the two events I've touched on above, which seem to resonate with the existing pandemic, don't sit within the scope of relevant matters. So contractors would only get time, but not cost. So this means no liquidated damages, extensions of time, but no additional payments. And this is why standard contracts don't deal with it. NEC, very briefly, the PM has to consider the effect of compensation events and make appropriate adjustments of time and cost. There are often requirements in these clauses, of course, for notification and detail, and absence of that tends to preclude the ability to claim. The event which stops the contractor progressing the works, which cannot be prevented. So this is the test of what is a relevant compensation event. It's an event which stops the contractor progressing the works, which cannot be prevented, in which an experienced contractor would have judged at the time they entered into the contract had such a small chance of occurring, it would have been unreasonable to have allowed for it. So go back 6 months, 12 months, stand up the contractor that spotted this one. But in terms of relevance to existing contracts, of course, we know about it. So if you're looking to enter into contracts, they'll be looking for variations to these provisions, because clearly it is something that they are aware of now and will not be able to claim if they've signed since the pandemic took effect. Again, it's not enough that the progressing of the works is made more expensive, it is that the works are stopped. And if it meets the test, the PM will make an allowance for adjustment of completion date and increase in price. And lastly, in terms of specific contracts, I'm going to touch on the JCT measured term contract. Clause 210.2 provides a degree of relief for reasons beyond his control, quote, and allows the fixing of a later time for completion, but not additional payment. And further, the MTC provides that if the supplier cannot gain access due to, we say occupier failure, but we're talking about the distancing rules and so on, then the contractor is entitled to its costs of delay. So that may give rise to something, but again, there are issues there. Now, moving into a couple of examples that Carl and his colleagues gave me. One was a kitchen bathroom replacement order, 3 months into a 6-month programme, work stopped due to the proximity risk issue with residents and also the supply chain. The intention is that works recommence once restrictions and material availability ease. The contractor is an SME and is identified at being at risk should the contracting authority consider paying in the normal way till the end of June. So the assumption is that there's no obligation to pay under the existing contract, and we're ignoring other remedies and so on by the client. So I remind you that you're not bound by the guidance. The usual tests will apply: commercial prudence, fiduciary duty, controls and limits within your statutory powers and governing instruments. The PPN suggests a starting point of the last 3 months' invoices to promote continuity and survival. supplier should make a claim. No work can be provided, then arguably it should redeploy or furlough the staff and claim under the CJRS. That is one route out. However, if work can be provided, then pay as usual, but identify the split between performance and impacted services. Now, there is potential here, although I think it's difficult to navigate through it in the PPN, as to whether if no work can be provided, you make a regular payment nonetheless. But it seems to me that the suggestion is that if no work can be provided for that period, then the effective mitigation is to furlough the staff and the contractor claim under the CJRS. So you need to consider insolvency risk, and it might encourage, as I suggest, you ask them to look at furloughing if that delivers less risk and less cost and is still a means of ensuring continuity. If you're going to make payment, then you have to be clear on job retention, supply chain and employment payments, and you need to check weekly, monthly as necessary under the open book terms and potentially through things like director certificates, supplier director certificates of what's going on, so that they are bound to it. There's a need to agree other things, of course, in the contract, extensions of time, waivers of KPIs. All of this will need to be bespoke based on what your contract says. And there's also a need to review and amend for removal of profit from non-provided items. And the end date, if you agree a variation, is going to be an interesting one. You need to agree that it's all going to stop on the 30th of June unless you, in your discretion, instruct otherwise. That would be an interesting discussion. Another question briefly, supply a contract with no volume guarantee, for example, adapted bathroom materials. What should the contracting authority consider paying? Well, a route through this could be, you could place an order and pay against that. Otherwise, the guidance would say not to, because it's not a volume related contract, but you could create the volume and create the opportunity where it's appropriate in voids or in other circumstances where work can be provided potentially as it arises in the period, and then make an appropriate arrangement. You could look at paying for materials in the supply chain, provided you were satisfied you would have title to them, and so on. And we've touched on the difficulty of occupied premises, but nonetheless, as I say, there may be circumstances in which it may be possible to do the work and therefore make a payment. So, Carl, I'm going to pause there. Appreciate there's quite a lot going on there, but are there any questions?
Nobody's raised a question. Oh, Gina's just asked a question. So, Gina, do you want to ask the question yourself? Unmute yourself.
Yeah, I mean, we've got kitchen and bathroom contracts which expire in March 2021. Due to COVID, it's fairly clear at this stage even that the contractor wouldn't be able to deliver the volume of works that we were proposing by March when the contract expires. So would they be entitled to an extension of time, or would we simply just push back any undelivered work into our following year's programme, but then it's uncertain due to tendering whether that contractor would be successful and would be the contractor in place at that time? Right.
Okay. Well, I'm going to give you the response, which goes like this. I'm not in a position to look at the contract terms that you've got with your counterparty, and the caveat that I'm not a construction lawyer, but what I've described in relation to the model form JCT contracts is there are circumstances where they may be entitled to an extension of time for completion of the works, but that may not be satisfactory to either party. So there is, and this is what the PPN encourages, there is a discussion to be had in terms of charting a way forward, ideally that does not overexpose the organisation, your organisation financially, but equally allows the opportunity for some element of continuity with the contracting party. So as I've said, the contract terms may well, as a result of this, allow for time and may well allow for cost, but you would be encouraged to have a discussion and sort of see what needs to be done, and extending time would be part of that discussion.
Thank you very much.
Brilliant. Thanks, Gina. I've got one from Sarah, who's part of our team, and it asks, if works cannot be carried out on a scheme and contractors' operatives are furloughed, should payment therefore then still be considered for the contractor's site overheads and preliminary costs in terms of their site establishment? Because obviously they've got those ongoing. They can claim support for the furloughed staff, so those costs to a certain extent are covered, but obviously contractors still may have back office overheads to cover, which he can't really furlough because he's still got to maintain some level of the establishment, and also obviously the site related prelims. Obviously, to an extent, those prelim costs, because under JCT purely it's an extension of time rather than an extension of cost in reality. You've said so.
Yeah, Carl, I think you make a good point, and I touched on this in one of the answers. The guidance is what it is. I mean, ultimately, as I say, if you were to sit down and, as a responsible organisation with each of you a degree of public policy, social and economic context of what you're doing, what you're trying to achieve through your spend and your relationships and so on, there is a strong argument for saying that this is something we should look to contribute towards, so that the contractor is in a position to carry on. Now, I don't think the guidance is necessarily massively clear on this question, that if the staff are furloughed, it's quite clear they shouldn't be claiming payment as normal, which includes staff costs. And I've sort of said, well, what do you do there? Is there no need for payment? Or it doesn't quite say carry on paying overheads and so on in that circumstance. But I think, in the light of the question you've posed, I think it would be a reasonable thing to do if it was evidenced, if it was mitigated, and if it was demonstrably necessary, to ensure that the contractor was able to resume performance in whatever way possible as we come out of this particular lockdown.
And then a follow-on question really from Michael Westgarth at Home Group, just sort of one around timing. So do you think it's reasonable to expect the contractor to explore all alternative forms of government support, i.e. mitigation, such as the furlough scheme, before approaching an RSL saying that they are at risk under PPN02? And I think you confirmed really they are expected to mitigate where possible, and therefore my view is you probably would say yes to that. Is that? Again, it's an issue of timing. There's a danger, just as if the organisation undertakes enormous amounts of due diligence, this will be hopefully come and gone in its worst phase before the output of that, such as it's worth doing. And likewise, if you say, well, please explore all other forms of assistance before you turn to us, that won't be dealing with the immediacy of here and now, because the big threat that they are trying to stop is that organisations, not just in your frontline contractor, but in the supply chain, are making staff redundant, and the shock that puts into the system. And we know that the contractors are highly leveraged, generally speaking, can have high levels of borrowing, and therefore cash flow is critical. And we know that the furlough scheme has only really just kicked in where cash will start to flow from that. Yet we've been in lockdown for a month or so, haven't we? So no, you're absolutely right. So what you're highlighting, sorry, Carl, what you're highlighting is at a practical level, you would agree to cover their costs. You would require them in that circumstance to diligently progress furloughing and make application for payment, and you would put in place arrangements as best you could to make sure that when they were paid out of the scheme, and as you rightly say, scheme payments are following some time after the event, that when they were paid out of the scheme,
they would reimburse you, but you would expect them to at least take the risk of properly implementing the scheme, and you would put controls over their ability to make staff redundant and so on who were furloughed. You'd want to be clear that that was the only measure being taken at that time.
Yeah. Have we got any other questions regarding the application of and consideration? It's quite challenging, isn't it, in terms of what is the expectation is versus obviously the risks as an organisation you put yourselves under regarding potential advance payments for contractors that are at risk of insolvency, and that's the biggest dynamic that's at play, isn't it, really, in terms of.
Yeah, and I think what every organisation will do, which is sort of what it does the rest of the time, but in different circumstances, is consider what its level of commercial and financial risk exposure is. But you're being encouraged to go to the boundaries of what you feel is comfortable, rather than be in the centre ground. That's roughly it. You're being asked to play your part, but it is ultimately up to you whether you do or you don't. It's quite difficult, I think, to draw a hard line between your action in supporting one or two contractors and whether there will be an effective competitive supply chain after the event. You're being asked to trust that if you do your bit, that it will. And if you don't, none of us really know what we're going to be facing in the autumn.
Correct. Are there any other questions before you move on to the next section? No.
Good. Okay. I'll take heart from that. So the final bit really is just a sort of look ahead. Carl had suggested to me, the issue of risk of recurrence, and I think, as I mentioned earlier, the guidance certainly has a sort of little catch-all clause in it. And we've got to be fair to people who've drafted this. This has sort of been rushed out. It's reasonable quality stuff, but ultimately it's been rushed out. And there's more to come. And it basically says that whatever relief and payment you get under this variation, it kind of comes to an end on the 30th of June, unless there's some sort of other event and we give notice that it's to continue on a similar basis in accordance with such rules and principles that will come out in relation to the follow-up event. So, at a commercial practical level, I say contractors will be saying, well, this is great to the 30th of June, but my supply chain may collapse and may still cause me difficulties for some considerable time. My input prices may be substantially increased. My delivery times, my workforce requirement may be substantially impacted by this. And so this just doesn't end at midnight on the 30th of June. And I think this is one of the challenges of the drafting. And I think it's particularly a challenge for clients who are entering into contracts now, where contractors may say, I'd rather wait and see what this looks like than potentially be on the hook for an unpriced risk post the 1st of July. So, looking ahead, the sort of genie is out of the bottle. Pandemic isn't covered in the broad sense of the term in pretty much any standard form of contract. Force majeure talks about biological contamination. Fortunately, one or two clauses talk about anything beyond reasonable control. But the risk is that what we see now is a sort of appetite to try and provide for pandemics or similar, let alone coronavirus 19 and any mutation of it. But clients and contractors wondering how on earth they're going to deal with this going forward, because it may not be enough to say after the 30th of June, we're now just going to rely on standard contract terms. So that touches on the question of whether pandemic becomes a standard variation to current compensation event drafting. And as I say, there are mutations of it, and we know there were other pandemics which didn't reach these shores or disrupt, particularly as we understand it, our supply chains. But I think it is going to colour how these things are dealt with. Now, the effects of the pandemic are clearly potentially catastrophic. Whatever we think about the current circumstance, whoever would have thought that the world economy would be put on hold largely for 3 months? We all thought it was a couple of weeks, didn't we, back in March? But it's pretty clear it's going to be the end of June. And for those people that read the regulations, you will have read that the powers, the Act and the regulations, the powers taken by government run for 2 years, which is interesting. They didn't just take it to the end of the summer, even though they thought the summer would see the relief of this. So there is going to be a need to look in the round at how this is dealt with in contracts, and the current drafting really just gets us over the current difficulties, and I don't think addresses the longer term implications in the way that it should. So standard contract suites will come under pressure to be adjusted, and where's that going to be? It's likely to be somewhere in the zone of time limited recompense, followed perhaps by termination or suspension. The alternative is what? That insurance, well, is the insurance industry going to step in and cover this? I think not. They can't insure the world economy from suspension, if not partial collapse. Will the government step in and effectively insure this risk going forwards, as they did with terrorism? I think that's something that might need to be considered. But at the moment, of course, the buck is being passed to individual parts of the broader public sector. But of course, the public sector cannot just afford to keep paying out for work that's not delivered and performance by a contractor that may not be around to deliver it, as the current issues, come out of suspension. Yes, if it's copper-backed by government, by perhaps something like terrorism insurance, some kind of pandemic assurance guarantee. So to conclude, really, as noted, none of the guidance addresses contracts which are being let now. They're having to navigate the emerging guidance and risk in changing circumstances. Even current contractors will be asking the question, what's going to happen after the 30th of June? Because it's probably pretty clear that we're not just going to go back to business as usual on the 1st of July as if nothing had happened. And where is the cost and disruption of that going to sit between client and contractor in these relationships?
Absolutely.
So those are my sort of final points.
Because social distancing, was it the chief of medical whatever for the government was saying we could be like this for a year in social distancing measures, applying generally in society, and that has a cost attached to it in terms of productivity on sites and things like that. So productivity will be affected by the additional burden of social distancing and disruption that has in terms of getting things done, won't it? More generally in our contracts, and that the route for that is not that clear at the moment contractually, is it, in terms of to be able to claim for that and adjust contracts accordingly? And I think that's the bit that's a bit still uncertain, isn't it?
Yeah, and at a practical level, frankly, again, this is challenging the comfort zone of public sector organisations. There isn't the time for clients, advisors and lawyers to spend a lot of time batting each other over the head over contract terms and so on in any letter variation, because cash flow here and security of employment is critical, and what is at risk if one I won't even say what the typical time for a complex deed of variation or letter variation is, but it wouldn't be unreasonable to think it might be several weeks, and that we're working in an environment where to get the benefit of this, really, these things need to be speeded up. So where there's an opportunity and an appetite to do something, there needs to be, dare I say, a high degree of trust and a high degree of acceptance of risk, particularly by the public sector body.
Brilliant. Thank you, David. Have any members got any further final last questions? I haven't seen any come through. The question I've got for our members is, have any members been approached for supplier support under PPN02 as yet? Or, second question is, what is members' views on the provision of support to their existing contracts where they have paused construction work to the contractors involved in that supply chain? I don't know if anybody wants to unmute themselves and just pick up on that.
Carl, it's Phil Lowe from First Choice Homes. We've had one at the moment that's in the offing from one of our contractors. What we've done is we've devised the supplier information form dealing a lot of the points that's in the guidance, asking for information about what costs they're claiming. And at the moment, that's going through our exec board, and then we're going to deal with that on a committee, in essence, that will review any claims that come through and set up a governance process. So that's where we are at the moment.
Yeah. Okay. So you're looking at it in depth, really, is what you're trying to say in terms of trying to consider all angles.
Yeah, I believe that. I mean, one of the main things that we have to do is to get a structured approach really with it, and it comes through a central portal. And the questions, I mean, I have pinched some of the questions from some colleagues in central government that they're on with it, but it gives us a structured approach and a rationale for whether we allow the payments or whether we don't allow the payments, depend upon obviously on a case-by-case basis.
Yeah, okay. I can see that Adam in Leeds has received a request as well. Adam, do you want to just share what you've received and how you're dealing with it?
Yeah, hi Carl, and thank you, David, for the advice that you provided there. In some ways, it's really heartening because I think we're largely in step with a lot of the guidance that you provided there. Our primary contractor on our repairs and maintenance, repairs, voids, and cyclical maintenance contract has sent in a request for support. Ultimately, we've seen now, as of last week's figures, around a 75% drop off in the volume of repairs that we're receiving. So obviously, our primary contractor is resourced to deliver business as usual levels of activity. So they have furloughed a significant proportion of both office-based and operative staff. However, they've kind of highlighted that for them to resource our essential services offer, and let's bear in mind we're still asking them to have all trades available 24 hours a day, 7 days a week. To resource that will cost more than they'll recoup in SORs, essentially. So the request and the agreement that we have in place in Leeds is back to an open book agreement, zero profit approach to our primary contractor that will effectively pay a break-even position over the course of the next 3 months to make sure that we can resource that essential services offer.
Yeah, which is a practical sort of solution, really, in terms of.
Yeah, and I guess going back to a couple of points that David's made. I mean, this particular contract is an NEC3 contract. There's no specific contract clauses that we can pin this to, so we have just tried to take a pragmatic approach to it, really.
Yeah. I mean, there is some model clauses in that FAQ for NEC3, isn't there, in terms of where you are providing supplier support to make sure that that's documented within your contract.
Absolutely, and I guess it was kind of the need to act was quite important, really. Obviously, the amount of cost that was accruing on a daily basis was significant. So yeah, we have obviously as a local authority, the governance element of this is critical to us. Again, David made reference to the sort of court of public opinion further down the line, so we're acutely aware of that. And from a contractual perspective, obviously tying all this back by way of compensation events, etc.
Fantastic, and thanks for that, Adam. Appreciate it. And Kevin, at St Ledger, you mentioned you've had a request as well. Do you want to share that and what your approach has been?
Yeah, I think we've had one on one of our planned for our planned contract, so it's not a response contract. And I think how the contract was set up is basically the contractor gets paid on completion of the works for each of the elements. So I think what we've done in light of the PPN is basically speak to the contractor initially around obviously paying them up to work the completed to date. So not necessarily releasing all the money, but obviously if they've 80% complete, releasing 80%, because obviously we thought that was in the spirit of the PPN. What the contractor is now exploring is, and I think you touched on it as part of the session, is around payment of prelims for the downtime. And obviously that we're just working our way through that, obviously in lines of what sort of clauses are in the contract and where that sort of risk liability. Really interesting for your comments, David, around obviously from a pragmatic point of view and a sort of a way to do it in the spirit of that notice, to look at obviously taking the staffing element out, but obviously looking at paying the overhead costs that they can't sort of divert anywhere else. So that was really interesting.
Yeah, brilliant. Fantastic. Well, I just want to therefore say, if there's no other questions, I think obviously Elaine's from THG said they've not had any requests as yet, but obviously it may well come, considering the length of period this is taken, and Jean has obviously sort of highlighted that she's had similar situation to what Adam highlighted in Leeds, in terms of they've agreed some support around their R&M contracts for similar reasons. I just want to say thank you, David, for supporting this session and for taking time out of your busy diary. Your expertise and guidance has been hopefully greatly welcomed by our members. And I just hope it's been useful for everybody to hear, obviously, David's views in terms of how we can apply what is quite a challenging set of expectations, really, in unprecedented times, to try and support our contractors, where we can reasonably practically do so whilst mitigating the risk, because that's the biggest challenge, is managing all those three aspects, isn't it, really, and trying to do the right thing without being caught in the middle in reality. So much appreciated. Thank you, David. And
thank you.
Unless anybody else has got any last final questions, I guess if they have, we can coordinate those through us and our team, and we can either help to coordinate those or respond back based on our understanding and following your guidance today. So I do appreciate that. Just a reminder then, in terms of future webinars, there are 3 or 4 others that we've got planned. So next week we've got one around apprenticeships. Obviously, we've got apprentices out in the field, and obviously colleges have been disrupted. Obviously, their work's been disrupted. Completing their apprenticeships has been disrupted. Obviously, they're more vulnerable as employees, and certainly experiencing furlough and mental health issues. And obviously, all the support that there is and how we see that playing out with CITB is the session that we've got next week on Thursday. I know that Elaine is organising separate conversations which we're party to, and we will obviously we're coordinating with Elaine from THG, her review, and there was a webinar that we held last Thursday, sort of considering how we exit on planned works from COVID-19 and get those restarted in a safe manner, thinking about working practices, what type of works contractors can do and can't do safely. So that's like a separate work stream that Elaine and WDH have been leading on, and we will obviously make, where we have joint sessions with contractors or as client groups, we're going to widen it out. Elaine, if you just want to say anything on that, if you can hear me still, if you're still with us. No,
I'm still with you.
Oh, hi.
Unmic the mute. I'm just trying to unmute the mic. Yeah, we're looking at the next one we're doing will be with contractors about the safe working practices and the things that they think they'll actually be able to deliver and where they're going to have issues with. Some real practical solutions and things coming forward from them to do with how they manage the day-to-day site activities. But it's a big operation looking at the risk and method statements about what we will and won't be able to do safely, so we can shape our investment programs accordingly. Yeah. And then SIG are looking at the supply chain with yourself, Carl, and everything for us. So then we can determine that if we do go and turn to an external program, how will the supply chain be able to cope with that? Yeah. Because obviously we're going to have to reshape our programs, and with the government announcement last night to do with the social distancing and things. Yeah. We could be here until we've actually got an effective vaccine, so that might put paid. to all our internal plan programs for this year completely. And I'm not sure the supply chain or the contractors can cope with a full switch from one type of work to another just yet.
Yeah. So I'll coordinate the wider membership input into that activity, Elaine, and work with you in terms of when we have those sessions organised to invite relevant members to participate in that.
That would be brilliant.
Basis. So we'll coordinate that together. But that's a separate work stream that Together and WH have been leading on, member led. And obviously we're keen to support that and make sure everybody can participate and take away some of the activity that's happening in there. We'll then be kind of summarising that activity then in a session on the 7th of May. All of these are on our website under EN Connect, and I'll issue out separate invites. And then we're going to have one on the 14th of May around new build housing and the impact of COVID on new build and what that looks like going forward. So appreciate your time. Thank you very much. And thank you, David. Yeah, brilliant. Fantastic.
Thank you.
Really good session.
Bye.